To discuss, we're joined by the Deputy Minister of Finance tonight, Dr. David Masondo. Deputy Minister, thank you for being with us. So tenders have been put on hold for around a month. Some people would be happy given what we saw during COVID-19, but I'm sure there's been a huge impact on government activities. Just tell us what the impact has been.
No, thanks, and Francis, for having me, and good evening to your viewers. No, government hasn't stopped tenders. So what has happened is that the court ruled that the minister has no powers to pass regulations that should govern state organs beyond Section 3, which deals with the threshold around, usually we'll say 90% competency, 10% BE in order for you to qualify. So there was a rule that said for you to qualify, there was a pre-qualification rule that there was a rule that allowed pre-qualification. So the court said the Minister of Finance has no powers to make rulings in that regard. Those rules should fall within the ambit of the state organs themselves. So what is not very clear from the court judgment was for how long, how much time do we have as a state to correct what the court found to be unlawful. So we've gone back to the court to seek clarity in that regard. Whilst we are doing that, we said we didn't stop procurement. Procurement should still take place. However, state organs and state institutions should simply apply to National Treasury for exemption from the PPFA Act so that they can procure the services, because all of us were governed by that act. And this is meant to avoid irregular expenditure. So we do not stop procurement, and the court did not rule, did not annul, did not cancel the BE in our state system.
All right, then it was hoped, I think, that going through the courts and new rules now being gazetted, although they restore 2017 rules, basically there would be some certainty. But now the Black Business Federation says it wants to fight this. Was the Constitutional Court ruling the end of the road about how this will all work, or do you expect a fight? Could it change in future?
So the court really was just looking at the powers of the finance minister. It simply said, Minister, you have no powers to set regulations beyond Section 3, which deals with the threshold. So BE is still permissible, it's still the policy of this government. And number two, we're in the process of putting the public procurement bill. And if you look at Section 4 of that bill, we're proposing that the state organs should be allowed to do set aside. So it's a question of where does the power lie in doing the rules for procurement beyond Section 3, which set the threshold for 10% black BE and 90% competency. So the court really did not say we should not procure, the court should not say we should not do BE. It simply said the rules should lie. So it just shifted certain rules to be within the ambit of the state organs themselves.
Well, please clarify, because I understand this is about the pre-qualification rules, so that those were used, you can correct me if I'm wrong, but those were used to help black businesses, to say sometimes this will only go to black businesses. Is that correct? Otherwise, why is a black lobby group, a black business lobby group, upset?
So you're right. There was a pre-qualification. The idea here, which has come from partly from this judgment, is that you don't pre-qualify, but you can make rules for preferential procurement in which you prioritize or you prefer black business, youth, women in the process itself. When you do the evaluation, when you do the adjudication of those tenders. But what seemed to be the issue is that you don't do that. You don't disqualify before people are assessed, both on the 90% competency and 10% either BE or women or youth. So you've got to allow, according to this judgment, the bidders to pass the first hurdle, which is to get into evaluation, but state organs are allowed to still set the BE scores for women, for youth, but you do that once you are in the process of evaluating such tenders.
All right, I understand. So you, as you said, this just moves the responsibility from Treasury then to those state organs down the line to set in place this criteria. Then can you evaluate what the Black Business Lobby Group is saying, that this leaves Black South Africans at a disadvantage?
I think we will engage the Black Business South Africa on this one, just so that we clarify where we stand, where government stand in this regard.
Are you saying it's a misunderstanding? They're getting this wrong?
It will seem it is. It is a misunderstanding because we're not doing away with the BE. The locus of power to determine the regulations on how state organs should procure lies now with the state organs. The only power that the minister still has is to set the threshold on the 90, 10, BE 90 competency insofar as the bids are concerned. But the decision on whether how they procure and the rules, that what the court said, that is not within the ambit of that's not within the powers of the minister. That should be left to the state organs. The only power that the minister has, it's section 3, in which we set the threshold, and that's the process of gazetting that we're undertaking currently. And we'll encourage people, including black business, to make their inputs in that regard. And I think the deadline is on the 11th of April this month.
All right, thank you for clarifying. The Black Business Federation raising issues, but you're saying a misunderstanding, still a lot of BEE preferential treatment in place if the state organs want it. I hope we can speak to you in future, Deputy Minister, about procurement in general. Thank you very much for your time tonight, Dr. David Masondo.